Blackman from South Texas College of Law in Houston, who is here to talk about executive power in the Trump era, particularly with the divided Congress and how he's wielding executive power. But we are doubly privileged today because we've turned our event into a debate with our local attorney, Chris Jackson, from Sherman and Howard. So we're going to get to hear multiple viewpoints, which is consistent with the Federalist Society's commitment to debate. Let me read you some bios real quick, please. As I mentioned, Josh is a professor at law at South Texas College of Law at Houston. He specializes in constitutional law, United States Supreme Court, and the intersection of law and technology. Josh is the author of the critically acclaimed, unprecedented, The Constitutional Challenge to Obamacare, a book which came out in 2013, and Unraveled, Obamacare, Religious Liberty, and Executive Power, which came out in 2016. He was selected by Forbes magazine for the 30 under 30 in law and policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on both immigration and healthcare. He's an adjunct scholar at the Cato Institute, the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy.
You should all play.
Yeah, it's like candy for law students.
Crack.
And he blogs regularly at joshblackman.com. He's the author of over 4 dozen law review articles, and his commentary has appeared in numerous national media publications. Welcome, glad to have him.
Thank you.
Chris is also an attorney, as I mentioned. He's a litigator in private practice, but his practice lies at the intersection of public and private law. On the public side, the media regularly turn to Chris for his legal analysis on the judiciary, elections, constitutional law, and the Colorado state government. He has been quoted over 50 times in the last couple of years in a variety of media outlets. In his practice, he channels his passion for politics to work with candidates, nonprofits, for-profits, and private individuals as they navigate their relationship with the government. He's represented clients on matters involving elections and campaign finance, government investigations, ethics issues, open records requests, the First Amendment, labor, and many others. On the private side, he represents clients in state and federal court on a wide range of issues: business torts, IP, securities, insurance agreements, and antitrust. He uses his experience with the media to address the PR issues that often arise in litigation. He works with clients to manage legal and non-legal risks. Before joining Sherman and Howard here in Denver, he served in the Colorado Attorney General's office, where he represented the state's senior public officials. After law school, he clerked for the Honorable Roger Gregory of the U.S. Court of Appeals for the Fourth Circuit. And the bio I grabbed for you, Josh, did not include your clerkship.
I clerked in the Sixth Circuit, but it doesn't matter.
Thank you, but in case anyone has questions about clerkship, everyone
Oh, yeah, please ask.
who has done a clerk likes to talk about it. So
Thank you.
I wanted to plug those. We're going to give them each a chance to talk about the issues of immigration, executive power in the context of immigration, and then we'll leave room for questions. But I'll start with you, Josh.
Thank you so much, Rachel. It's a pleasure. My first time at DU. I've been to Boulder a few times, but my first time here, so it's a pleasure. Our topic today is executive power, and in particular, executive power in the context of immigration, given a divided Congress. And Chris and I agreed to talk about 2 broad themes that overlap. First, Hawaii against Trump, which was the travel ban decision from last term. And second, the wall, right? I need say no more. So I'm going to start with the wall, and I'll work my way back to the travel ban. Throughout the 2016 election, Donald Trump campaigned for president the promise that he would build a wall along the southern border. And full disclosure, I did not vote for him. I don't plan to vote for him again. I think the wall is a silly idea for a lot of reasons, but I'm going to stick here to the legal issues. Okay. He won the election on the promise of building the wall. Now, you may not know this. 6 weeks after the election in November 2016, Congress passed a statute, 10 U.S.C. Section 284. You've probably never heard of it. Okay? This statute authorized the Secretary of Defense to support, quote, the construction of roads and fences and installation of lighting to block drug smuggling corridors across international boundaries of the United States. So again, in November of 2016, after the election, the Democrat-controlled Congress the Democratic president, Barack Obama, signed into law a bill that gives the Secretary of Defense the power to build fences along the border. No objection. We have a problem here, right? We all knew what Trump wanted to do. He told us a million times. But then Congress passes this 1,000-page bill with this little nugget buried in there that says, Mr. President, you can now build walls and fences along the border. Okay? Congress long ago stopped legislating. Congress, by and large, has given up its legislative powers. Instead, Congress of both parties delegate vast amounts of authority to the president. Often they just don't think about it. They put a statute in there because the government asked for it and they don't really care. Other times they pass a vague statute knowing that a president that they like and agree with will do stuff that they like. What happens when Congress enacts laws and we get another president who we don't like? Let's just call him Donald Trump for a minute, right? What happens when Congress passes statutes that give vast amounts of power to the White House and then President Trump says, okay, I'm going to use that power? That's precisely what happened in both the travel ban litigation and the wall. Fast forward to February of 2019, about 2 months ago. President Trump invoked this express statutory authority, the one President Obama signed, to construct fences along international borders. Even worse, Congress appropriated money for those fences. Almost $2 billion to build fences. Now, this money does not turn on the declaration of a national emergency, which I will talk a little bit later. This is solely to build fences to block drug smuggling. If you notice, he's been talking a lot about fences instead of walls. And he's talking a lot about drug smuggling. He was laying the groundwork, the predicate, to invoke the statutory authority. So what we have here is Congress willingly gave the president the power to build at least part of the wall, right? With no strings attached. Recently, the House of Representatives announced that they're going to sue the president in court to block the construction of the wall. I think there are a lot of reasons why this lawsuit isn't going to work. The most basic one is if Congress isn't happy with how the money is being spent, they can just decline to appropriate the money for the wall to be constructed. Appropriation bills last 2 years at a time, and Congress can just say, in 2 years, we just will not renew the funds. But I think the Congress, both in this administration and the last one, has turned to the courts in areas that they probably shouldn't have. Now, the wall is not the first place where the president's relied on express statutory authority. Let's move on to the next topic. So, the travel ban. In the 1950s, Congress enacted another statute, 8 U.S.C. 1182. Right? Let me read it to you. This statute says that the president can deny entry to aliens or any class of aliens that he deems detrimental to the interests of the United States. Again, this was passed during the Eisenhower administration, right? During the Cold War, in a very different era. But this statute was left in the books for decades upon decades. It was used by Presidents Carter, Presidents Clinton, President W. Bush, and they all used it in fairly limited fashions, right? To block entry to Iranians during the hostage crisis, or maybe to block entry to Cubans during a diplomatic tiff. But the statute's really broad. Fast forward to Donald Trump. He campaigned the promise of denying entry to aliens from certain predominantly Muslim nations. He said it 100 times. He comes into office, and then a few days after the inauguration, he signs what's called the executive order, the travel ban as it became to be known. He wasn't relying on some sort of inherent constitutional authority to block entry. He's saying, hey, look, Congress, you said the president can deny entry to aliens he deems detrimental, and guess what? I deem these aliens detrimental. The reaction to the travel ban was swift. He was sued in courts across the country. A number of judges issued nationwide injunctions. We know this history. But what has Congress not done? Congress hasn't tried to repeal Section 1182F. The very statute that gave Trump the power to issue this ban, Congress hasn't tried to repeal it. Why? I can take a guess. It might handcuff a future president they might like. Congress hasn't tried to repeal the emergency declaration provision. Why? Because that might handcuff a future president's policies they might like. I'm building to a general point here. Congresses tend to love executive power when their guy or gal is in charge. It was awesome when President Obama was able to use executive power to help the Dreamers out, or to make the implementation of the Affordable Care Act smoother, right? There wasn't any sort of opposition to those actions, and I can talk about those later if you want, but there's a lot of shady stuff going on. Trump continued it in large part. A lot of the illegal things Obama did, Trump is doing now. But now that you have a president like Donald Trump, who's actually using the powers Congress gave them for very different purposes, not to expand immigration, but to contract immigration. Not to expand health care, but to contract access to health care. And we get this very different, right? This very different approach. Indeed, a couple weeks ago, Congress voted to disapprove of President Trump's emergency declaration, right? It passed both houses. President Trump then vetoed it. But again, what Congress didn't do was to put limitations on how presidents can invoke these powers. So I'm going to now discuss two ways that that Congress and that the courts can perhaps remedy this situation. The first concerns the Emergency Powers Declaration, right? The wall funding is not just one area. President Trump's looked at three different sources. There's the fence to block drug smuggling. There's some other discretionary funds which aren't very controversial. And then there's the third one, which is the emergency declaration. That's one that you heard about on the news. And the statute is called the National Emergencies Act, passed in 1976 after the Watergate scandal with President Nixon. This statute is pretty broad. It basically says the president can declare an emergency when he deems it an emergency. The statute has no guidance, no specificity. It doesn't say what an emergency is. It doesn't say how long it can last. Congress really has no say in the matter, right? How can Congress block an emergency declaration? They have to pass a bill, which the president can veto, and they have to override the presidential veto. You might remember from a case called INS v. Chadha, right? You can't have a one-house veto. That is, Congress can't pass a bill without the president's signature on it unless you override the veto. So what we have now is that the president declared an emergency, which by any extent of the English language is not a real emergency, but it's an emergency under the statute. Congress said, no, there's no emergency. President Trump tweeted veto. That wasn't the actual veto, but he then actually vetoed the bill. So as it stands now, the emergency is still in effect, indefinitely, so long as President Trump's in office, I suspect. Now, here comes the problem. Merely declaring the emergency doesn't do a damn thing. The declaration of the emergency has a different effect. It's to open up other pots of money, right? By declaring the emergency, Congress has made available other areas of money. So again, it's not that the president is spending money without congressional approval. He's spending money, he claims, because Congress already approved it in advance. They said, if you declare an emergency, here's the money you can spend. Now, I'm not that big of a libertarian, right? I think there should be reasons why the president has this flexibility. I'll give you an easy example, right? Let's say we're back during World War II, and the military receives alerts that the Germans are powering submarines into New York Harbor, right? They're crossing the Atlantic, and they're going to be putting submarines in New York Harbor. Okay, bad. At the time, Congress is not in session, and then the commander says, you know what? Let's put some fortifications, let's put some mines, let's put some fences, let's put some nets in the water, right? Let's do something to stop these submarines from entering New York Harbor. And I don't have this money available exactly, but let me shift some stuff around and we'll do this because priority. I think everyone agreed that's probably a good idea, right? If there are submarines coming to the harbor, you got to move quick. You got to put some sort of fortification, barrier, whatever you want to call it, to prevent the subs from coming in. So I think the National Emergency Act is actually in the right idea. If the military needs to construct stuff in light of an actual emergency, they shouldn't have to wait for an appropriation bill, which might be 2 years down the road. I think we all agree with that. So as a basic principle, we should have limits. We should have discretion. But the problem is how the statute's structured. And this is Congress's fault. Congress says that the president can keep spending the money unless we override the veto. Flip it. My proposal, which I think is good, the Washington Post liked it, they picked it up in their op-ed, their editorial, is that all declarations last 90 days. After 90 days, Congress has to vote to extend it. And if Congress doesn't extend it, then the emergency ends. This is more or less modeled after the War Powers Act, which you probably studied in your common law classes, which says generally the president can engage in military action for up to 2 or 3 months, depending how it works, without congressional authorization. Right? The reason why this is important, it shifts the burden. It's now Congress's choice whether to continue the emergency rather than the president's choice to keep it indefinitely. Okay, so that's the legislative solution, which I think is a lot easier. The judicial solution, I think, is a little bit tougher, right? And it involves a principle of law, which you probably haven't thought about since 1L common law, called the non-delegation doctrine. You're getting the shivers, right? Bring the New Deal back, right? It's a general basic principle that Congress passes laws and the president executes them. If only were that simple. Since really the beginning of the Republic, Congress has given various administrative agencies the authority to do stuff. And generally Congress says, here's what we want done, and here's how you should do it, and then the executive does what Congress says. That's fine. I don't have a problem with agencies doing stuff. I think it's an important aspect of our government. But the problem is we have these vague statutes. And I mentioned 3 today, right? First, we have the travel ban, which says that the president has the power to deny entry to aliens that he deems detrimental to American interests. Doesn't say what detrimental means. Doesn't say how long he can deny entry for. Doesn't say how many people he can deny entry to. It's completely open-ended. And actually, some of the judges in the Fourth Circuit, where Chris Clerk suggested that the travel ban statute actually violates the non-delegation doctrine. I think it was actually, was that Judge Gregory's opinion? I think it was. I read a very critical piece. I think it was. I read a very critical piece of him, so hopefully you don't take it personally. But some of the judges actually said that the travel ban statute violates the non-delegation doctrine. I agree, except there's also constitutional power. I think as a matter of Supreme Court doctrine, the president can deny entry without a statute. Cases called Shaughnessy versus Exrel Knopf. The president has inherent power to do this, so the statute is actually not that relevant. But I take the argument well. So first, the travel ban. Second, let's talk about the wall, right? The statute says the president can declare an emergency. Doesn't say how long the emergency lasts. Doesn't say what the emergency is. And once you have this emergency, here's like billions of dollars of money that you can spend without any strings attached to it. I think there's a credible argument the National Emergencies Act, in some cases, may actually violate the non-delegation doctrine. If the president's not acting on any inherent authority, it goes too far, right? The president has no Article 2 power to build a fence, right? Domestic, to build a wall, right? The president actually has not cited Article 2 as a justification to build a wall. And then we come back to, the statute that the president can build fencing to stop drug smuggling. Well, that's more problematic, because that's pretty specific. It says you can build a fence along the border to stop drug smuggling. If, incidentally, that fence also blocks migrants crossing, maybe. So you have like 3 statutes, right? You have the travel ban statute, you have the emergency statute, and then you have the fencing drug statute. And they have different degrees of delegation. Congress should move forward to put more specifications, but if they don't, I think the court should pick up the slack. And I think they've dropped the ball significantly and allowed the administrative state to get too big. I think the court should declare the Emergencies Act unconstitutionally vague. Need more guidance, need more of a limiting principle, need an intelligible principle. Don't just say emergency, it has to be something more specific. And my hope is if the courts start to actually put more teeth into these sorts of statutes, then there'll be more accountability, right? Congress can complain, oh my God, we hate the travel ban, but you're leaving in place a statute allowing the president to deny entry. Right? Congress says, oh my God, we hate these emergencies, you're leaving in place a statute allowing any president to declare an emergency. Put your money where your mouth is and actually assert a power and how the president has to go forward. Congress must take seriously its constitutional role during times of war and peace. If there are enough votes to terminate this present emergency and override the veto, which there aren't, it's used as support to prevent the problem from recurring. It's not enough to stop Trump because Democrats oppose a border wall, or to simply rescind the emergency authority because members of Congress, both sides of the aisle, are uncomfortable with the actions of this particular president. To maintain the separation of powers, Congress must reassert its constitutional mandate to legislate and appropriate, rather than lazily passing a blank check to the White House, regardless of who resides in it. Thank you so much. I turn to my friend Chris, and I welcome your questions. Please, yeah, please.
So thanks everybody for being here today. I'm really appreciate the invitation to be able to participate in this. I want to start by making an introductory point that I think will inform the broader discussion that hopefully we're all going to have, and it's something that I think the two of us disagree about, kind of how we should address the issue. And that is Donald Trump's rhetoric and the creation of an imaginary president. So I know the president's more outrageous statements get repeated a lot, but I do think it's worth focusing on a couple of them in the immigration context to get a sense of kind of where we are. There is his history of birtherism, the patently false and odious notion that Barack Obama wasn't born in the US, his repeated statements that immigrants, and in particular illegal immigrants, are criminals, rapists, and bad people, the references to enacting a complete and total shutdown of Muslims entering the country. That's something I'll talk a little bit more about with respect to the travel ban. And his stated goal to override the 14th Amendment's guarantee of birthright citizenship. My point in giving these examples is that Donald Trump is not a calm, deep-thinking Reagan-era conservative who has an honest concern about the number of illegal immigrants in this country. But I'm not trying to take potshots at the president either. I'm giving these examples because what I often see in defenses of a particular Trump administration policy is the construction of a person or of a president who doesn't really exist. So if a rational president were concerned about illegal immigration and terrorism, as people have argued, he might enact what we've been calling version 3.0 of the travel ban, the one that the Supreme Court eventually upheld. But that, of course, ignores the president's and his advisors' actual statements over the last several years about the policy and what it meant. If a rational president believed in the attitudinal model of judging, where there is, in a real and important sense, Democratic and Republican judges, he might be critical about which judge he drew in a particular case, which of course ignores the president's comments about Judge Gonzalo Curiel and the entire Ninth Circuit, among others. Many of the defenses of the Trump administration's policies focus on what I see as a narrow legalistic argument that divorces itself from the facts that are in the real world. And I've read a couple of Professor Blackman's comments. I don't want to speak for him. I think that we have a similar viewpoint about kind of what the world is, what it looks like, but I think we do disagree about what the response is. And the way that I would phrase the question, whether there's this technical, legalistic view which tends to ignore the facts on the ground, is the kind of view that the courts should take when they're reviewing decisions by the Trump administration. So I want to talk about the travel ban relatively quickly. So the issues in this case, Trump versus Hawaii, can be broken down into kind of two different areas. I'm ignoring the justiciability concerns that the court talked about in some detail. So there's the statutory question, which is whether the INA grants the president the authority to issue this kind of an order. And then there's a constitutional question about whether this particular order violated the First Amendment. On the statutory issue, I do think that the majority mostly got it right. I'm not an expert in immigration law by any means, but I do agree with Josh and with what other people have said that this statute gives the president just a ridiculous amount of discretion. I think Chief Justice Roberts was right when he said it exudes deference in every clause. And so I don't think the plaintiff's argument on this point gets very far, and the dissent doesn't really address it either. So that leaves the big issue, as I see it, which is whether the proclamation, this is the third version of the travel ban that the Trump administration enacted, whether it violates the Establishment Clause. And the plaintiffs used a phrase I thought was interesting that I hadn't seen before. They called it a religious gerrymander. The argument being that what they really wanted to do was to limit Muslims from coming into the country, to ban them entirely. But what they decided to do was kind of gerrymander and pick a particular set of countries that are most likely to capture those people without actually calling it a Muslim ban. And so the question is, does this violate the Establishment Clause? How do we evaluate those sorts of claims? As a threshold question, we have to figure out what kind of review a particular court should employ. And there are at least three options for that. The first is adopting an older Supreme Court case, Mandel, which is what Chief Justice Roberts did in the Trump versus Hawaii case. And that asks a limited review of whether the executive gave a facially legitimate and bona fide reason for its action. I think there's some debate on this point, but the general consensus is you just look at the declaration or the proclamation itself and decide, is there some sort of a facially plausible explanation for why it exists? If you want, you can go up a step in the kind of review that a court should enact and talk about rational basis, which is, at least according to Chief Justice Roberts, whether the entry policy is plausibly related to the government's stated objective to protect the country and improve vetting processes. If you want a third set above that, you can adopt what a lot of people talk about, kind of standard domestic establishment clause jurisprudence. I think the dissent relied on a case called McCreary versus ACLU of Kentucky and ask whether a reasonable observer would view the government action as enacted for the purpose of disfavoring a religion. So the question is, which of those tests should be used? That's a lot of background. It's a lot of doctrinal detail. And I will tell you that what I think at least the answer should be is some kind of version of standard domestic establishment clause jurisprudence, the McCreary case, with a bit of a thumb on the scale in favor of the government because the executive does get some deference when it comes to matters of national security and foreign affairs. But I don't care all that much, honestly, which doctrinal hole we try to fit this case into. I think the lowest level of the court adopted is probably not right, but whether it's rational basis, whether it's McCreary, whether it's something else, some kind of amalgamation of those two, I don't think that's as important. I care less about that than I do about the agreement of a broader principle. And I think that if we can get agreement on this broader principle, then the particular case, Trump versus Hawaii, isn't that hard. And the broader principle is this, that while the president should get some deference on national security and foreign affairs issues, his powers are constrained in a meaningful way by the First Amendment, and that constraint is enforceable by the judiciary. If we can agree on that basic principle, I don't think this case is that hard. And I'm going to talk about that in a little more detail, but kind of a point about why I think that principle is so important is the Supreme Court clearly did not articulate or adopt that principle. The court's theory, which relied on Mandel, or depending on how you looked at it, applied what I would call a particularly toothless form of rational basis review, is the same as not having any review at all. It's a homework assignment. Draft a few pages in the proclamation and sprinkle the phrase vital to national security a couple of times throughout, and that's all the court is ever going to look at. And so I would argue that I don't think that the Trump travel ban, the version 3.0 that actually was reviewed by the courts as kind of a semifinal decision, would pass rational basis, would pass McCreary, and honestly would pass anything except really what the Supreme Court, whatever standard the Supreme Court actually ended up adopting. So let's talk about rational basis. Chief Justice Roberts writes, "We may consider plaintiff's extrinsic evidence under rational basis review, but we will uphold the policy so long as it can reasonably be understood to result from a justification independent of unconstitutional grounds." And so Chief Justice Roberts, along with Sotomayor in her dissent, seemed to think that the answer to that question is totally binary, that it can only be one or the other. Either the policy is 100% the product of a constitutional justification or a constitutional basis, or it is 100% based on an unconstitutional concern. But previous Supreme Court cases have confirmed the obviously true fact that people can do things for more than one reason. And if some of the justification for a particular action is, for example, unconstitutional religious animus, then the government doesn't get the same level of deference. In other words, mixed motives are enough for the court to take a serious look at what the government has done. And I would say in this case, it is unreasonable to claim that Travel Ban 3.0 isn't in fact a Muslim ban. So on the one hand, you have the president's and his advisors' statements. I don't want to exhaustively categorize everything, but again, here are a few examples. Most obviously, Trump called for the complete and total shutdown of Muslims coming into America, along with a ton of statements over several months talking about how Islam hates America, they want to destroy us, etc. In talking about the Muslim ban, Trump explicitly referenced Japanese internment in World War II and the Korematsu decision, and essentially argued it's fine because Roosevelt did it. Rudy Giuliani, one of his advisors, gave a public interview where he said Trump told him to draft the Muslim ban, but said, show me the right way to do it legally. As Trump signed the first iteration of the travel ban, the one that the rest of the executive branch didn't really get much heads up about, he read the title, Protecting the Nation from Foreign Terrorist Entry into the United States, and then he looked up and he said, we all know what that means. And I would ask, what else could President Trump have done to make clear what he was really trying to do, other than to say, wink, wink, nudge, nudge, it's about the Muslims? After the proclamation was issued, so this is the version 3.0 of the travel ban, Trump said that this was just a watered-down version of the first one, that it had been tailored at the behest of his lawyers. He said it should be far larger, tougher, and more specific, but stupidly, that would not be politically correct. So I would say that when the government came up in the Trump versus Hawaii case and argued on behalf of the United States before the Supreme Court and said the travel ban was totally based on national security concerns and didn't have anything to do with racial animus, that is basically the dictionary definition, I think, of someone saying, who are you going to believe, me or your lion eyes? Everybody in America knew what this was kind of really about. So that's sort of on one hand, the extent to which religious animus motivated the Trump administration's decision. On the other hand, that you sort of have to weigh, you have to consider national security, which is a valid interest that presidents have a unique position, a unique responsibility for. But consider this, that in the 15 months of the travel ban litigation, no government official ever submitted a sworn affidavit that described how the policy served national security or the process that led to the proclamation's adoption in any detail. The administration couldn't really articulate how or why the travel ban would serve any kind of government purpose that wasn't already served by existing law. And so in short, I would say I don't think the travel ban can survive any level of appropriate scrutiny. A couple of other pieces about the travel ban litigation. So first is its comparison to the Masterpiece Cake Shop decision, which was decided by the Supreme Court that same term. This was something that Justice Sotomayor brought up in her dissent, and I think got a lot of traction when the decision handed down. So recall that Masterpiece Cake Shop was about a case in Colorado. There was a baker who refused to make a cake for a gay couple's wedding. The Colorado Civil Rights Commission filed a complaint against the baker, and the baker argued that the First Amendment allowed him to turn down the request. The court, in its decision, largely ducked all of the interesting, important questions about weighing religious freedom with anti-discrimination principles. Justice Kennedy wrote a majority opinion that I think was 7-2, where he said, effectively, that a couple of statements that individual members of the Civil Rights Commission made during a hearing, but which didn't make their way into any kind of a final order, displayed anti-religious bias, and that it was so bad it infected the whole proceeding and the whole thing had to be reversed. And I would argue Trump versus Hawaii is just like that case, except worse. The religious animus is far more clear. Now, many have commented that the analogy doesn't hold because the president is in a different position than a Colorado Civil Rights Commissioner. And I think that's a fair point. Presidents are in a different position. But this goes back to my original argument about the standard of review in Establishment Clause cases. Presidents, I grant, do get more deference with national security than Colorado Civil Rights Commissioners do when it comes to enforcing accommodations laws. But that doesn't mean that the president's actions are totally unconstrained by the First Amendment, and it doesn't mean that they're totally unreviewable by the judiciary. There is a middle ground. The last point I'd make on the travel ban case was Justice Kennedy's concurrence. This was, if you'll recall, the last opinion that Justice Kennedy wrote as a justice on the court. And so he starts off by saying, there are some things that aren't reviewable by the judiciary. That is a true statement. He hints, but doesn't explicitly say, that the travel ban is one of those things. But, he says, even if the Supreme Court can't review something, government officials should really think about the Constitution anyway. He writes, and imagine, I will just give the quote. The oath that all officials take to adhere to the Constitution is not confined to those spheres in which the judiciary can correct or even comment upon what those officials say or do. I think this is a perfect example of what I mean when I say we're constructing a president in a world that doesn't really exist. These are important, complex issues that adults need to grapple with because they have real consequences for real people. And Kennedy, in his last statement as a justice, is essentially lecturing people like they're school children. Can't you all just play a little more nicely, and can't you all just take the rules a little more seriously? Just kind of my general thoughts about the travel ban. I realize we might be getting a little short on time, so I might talk just a little bit short about the emergency declaration. So the legal background, which I think Josh did a really good job of talking about, is the Trump administration wanted more money to fund the border, and they went through 3 different ways, 3 different mechanisms to get there. And so I know Josh talked a lot about, I think it's 10 U.S.C. 284, is that right? Yeah, I wrote that down. Didn't know that until after you said it. So that and I think that we agree on that point, that is a relatively uncontroversial statute. We can talk about non-delegation and stuff like that. We can talk about whether this kind of a law really fits under the statute. But I think the more important question, the one that goes to executive power, is the particular statute under the National Emergencies Act, the one where President Trump declared the national emergency in order to get more funding that the Secretary of Defense can actually use to undertake military construction projects. And so the background, the legal background for this kind of question is about the scope of the president's executive powers, which people usually start by talking about Youngstown Sheet and Tube Company versus Sawyer, the steel seizure cases. If you'll recall, this was a case where there was a national steel strike. They tried negotiating it, and Truman decided to just seize the steel plants, invoking his inherent authority under Article 2 of the Constitution. So he wasn't relying on a statute. It was just his inherent authority as president. Justice Jackson's concurrence has taken to kind of be the framework for these sorts of cases, and he's talked about 3 different categories. Cases where the president was acting with express or implied authority from Congress, where his power is at its zenith. Cases where Congress is just silent on the issue, doesn't say anything, this is the zone of twilight. And then third, the lowest level, where cases where the president is defying Congress. Now, I would argue, and I think this is the point that Josh and I would disagree on, that this is in fact a case where the president is defying Congress. I read the background about the border wall funding a little bit differently. If you'll recall, there were negotiations for weeks about whether or not the government was going to agree with the president's request for border wall funding. For weeks, Congress pointedly refused to appropriate any money for this purpose. We, in fact, had the longest government shutdown in American history because of this exact issue. After the fact, when Trump went ahead and declared the emergency to try to get the funding, Congress passed a joint resolution revoking the emergency declaration, which the president promptly vetoed. I agree with Josh that Ioannis versus Chadha. I think that's actually why the National Emergency Act was changed in that way, to make it a joint resolution instead of a concurrent resolution. So, that was the way that it needed to be done, but that makes clear that Congress did not approve of the use of the funding that the president was asking for. And so what I'd say on that point is that this is what the separation of powers in the Constitution is meant to do. The Constitution reserves the power of the purse to Congress. 2 Congresses have refused to give the president the border wall funding that he requested. Congress also passed a joint resolution to revoke the emergency declaration. And what you have is essentially an attempt to circumvent this constitutional command through a manufactured emergency that the president himself admitted when signing the declaration that it wasn't actually an emergency. And so my argument is that if the statute itself isn't that clear, and I think Josh and I have a little bit of a disagreement about whether the National Emergencies Act permits this, whether this actually is an emergency, whether that's judicially reviewable, whether this kind of funding can be used for this sort of issue, sort of cabining those statutory issues aside. But I'm saying that if reasonable minds could disagree about the interpretation of the statute, then the courts, and in particular the Supreme Court, should rule in a way that preserves the separation of powers, that recognizes that Congress has essentially told the president no. I have a couple more thoughts. I think it may be good to sort of wrap up, to do questions, a couple of closing thoughts maybe afterwards, but I think that's about what I've got.
Sure. Thank you. I think this is useful in a couple ways. One of which is we had a civil discussion and we didn't yell at each other. I didn't throw anything at him. He didn't throw anything at me. And I think one of the reasons why I love Federal Society Talks is you can have people who largely disagree on a lot of things, find points on which they do agree, clarify the points which they disagree, and then students, you can make up your own mind, say, well, Josh had this point and Chris had that point. I think that's very useful. I have a limited time, so I'll focus primarily on the travel ban's too much. I can't do this in 5 minutes. So I'll focus primarily on the Wall Declaration. And I think this is a very good Youngstown question. In fact, this is one of my favorite cases in all of law school. And I think Chris gave you the facts. So let's actually drill down what happened in Youngstown, right? In the years before the case arose, Congress debated, should we give the president the power to seize steel mills in the event of a labor strike? Congress considered that precise question. And Congress ultimately said no. They gave the president some emergency powers in the case of a labor strike, involving mediation, things that aren't very important. But Congress expressly declined to give the president the power to seize the mills in the event of a strike. Okay, but let's do a hypothetical, right? Let's just give a counterfactual. Let's say Congress passed a bill which said the president cannot seize the mills in the event of emergency. They pass a statute, right? The president then vetoes that bill. And Congress lacks the votes to override it. What does that tell us, right? How do we apply the Jackson framework to this hypothetical I just gave you, right? Where Congress says, don't do something. The president said, okay, I have my veto pen, #sad, right? I'm going to veto this. And then Congress lacked the votes to disagree, to override the veto. Does that mean that Congress supported the action? Does that mean that Congress opposed the action? What does that mean? The president was within his rights to veto it, which is why I think the Jackson framework, which I love, 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 is very hard at resolving tough questions. And indeed, in later cases where the court has applied Youngstown, they've done so in a very open-ended way. So do you study a case in Conlon called Dames and Moore versus Reagan, right? It was a case from the early 1981, I think. It was right after Reagan took office. The question was this: could the President Reagan, suspend a litigation against Iran? Right. This is after the Iranian hostage crisis, and President Reagan said, "You know what? We need to end all hostility between our countries. We're going to suspend all litigation." Congress had never passed a statute which says the president can suspend these claims, but the court said, well, they've done other things, right? And they're okay with what the president's doing. So even though there's no specific statute, said, well, Congress did other things which sort of authorize it. So the Youngstown framework, I think, Jackson did the best he could. And I think Jackson explained there are not clear authorities. I think it's helpful. But in the context of Trump, it's less clear to me whether Congress actually is on record in the way Chris suggested, right? Congress passed, authorizations year after year, knowing that some president in the future could use this power in a way they might like, and they haven't rescinded it. For certain, they tried to override the veto on this declaration, and they fell short to override the veto. And Jackson wasn't specific, but the tenor of Congress, is that based on whether they passed the bill in the first place, whether they override the veto? I don't know. So I think this case doesn't really turn on the constitutional question. Trump hasn't asserted any sort of Article 2 powers. But I think the Youngstown question does inform the level of deference that the executive should get in construction of the statute, which then bleeds back to Chris's main point. What deference does the president do? I think this is where we probably the biggest disagreement on, I think, by a mile. I think the executive should get more deference. And sometimes it's doing something where I know the reason giving probably isn't the right reason. And for a host of reasons, which I don't have time to discuss, I think the courts have to go along with it. Especially in the context of foreign policy, which travel ban was. I think the wall is a little bit different because it's domestic. I won't give the president the same thumb on the scale, to use your turn of phrase. In the domestic context, of the spending domestically. But in the foreign policy context, I think rational basis was appropriate. I think the Mandel test was was the right test to apply. I think the court got it right. I can talk later how I don't think the Establishment Clause applies to aliens seeking entry, which is my primary point. I think the Establishment Clause is irrelevant. We have lots of visa categories depending on what religion you're in, right? We have special visa categories if you're a Jewish or an evangelical refugee, right? We have certain visa categories if you're a priest or a minister, but not if you're, certain other kinds of religious officiants. We discriminate a lot on the basis of religion with respect to immigration law, a lot. And I just don't think the Establishment Clause controls this action at all, which is why I was more comfortable with rational basis scrutiny. But I see Chris's point very well. I think he articulated the point that Justice Sotomayor made with precision about, we can't put our heads in the sand. We should look at what's going on. So really, Trump against Hawaii is a case of deference. If you agree with me on the deference question, it's an easy case. If you're with Chris on the deference question, it's an easy case, which is why I think it splits so sharply down the middle. I'll stop there. Thank you so much. And then if you rebuttal or questions or whatever you want.
It's like a couple of...
Please, yeah. Yeah. Going up and down, yeah.
Yeah, so a couple of points. I think I agree that the Youngstown framework, it's an odd to try to map it on in this case because, what you normally have is an actual law is passed, and it's usually passed by a different president, and then another president comes in, and there's sort of a question about this Congress and this president. So it's odd to have it mapping on. I think the best way probably to think about it is that there are three broader categories that Jackson was talking about. There are gradations within them, and so this is kind of a screwy case that I think is pretty closely to the lowest end. So going down here, but you can sort of make an argument between the second and third categories. On Josh's point about the Mandel test being the right test, I think I agree that is a point that we disagree about. And I would just sort of re-emphasize that, honestly, if you're going to do Mandel, just don't have judicial review. Just say that's a non-justiciable question and move on. Because if Mandel really is all we're going to do is look at a proclamation and just say, I don't know, does it say national security on it? It seems good to me, then we're done. It doesn't do it. What it means is, and the hypothetical is basically what happened, the president can say whatever he or she wants about this thing and say, what I'm about to write is 100% false to the public, and then write something out, and the Supreme Court's going to say, we can't talk about the fact that the president just contradicted him or herself from the actual declaration. So if Mandel is the test, I think you might as well just not have a test. And
I agree with that, actually. I actually would use the same formulation. I agree 100% with that.
And I think, too, and not just as a matter of because it's not worth it, but because what you're doing is you're giving judicial legitimacy to something that the court isn't really reviewing. If they're not going to be a part of it, then don't be a part of it. But don't sort of review it, but then not do it.
No, I agree with that entirely.
The Establishment Clause not being applicable to immigration, I think we do disagree on that. I think there is historically a difference in how immigration law works when it comes to freedom of religion. But I think maybe it's enough for me to just point out that while there may be some differences, I would say A, past practice doesn't mean that the First Amendment doesn't apply. And B, in particular in this kind of case, this isn't just about Establishment Clause in the sense of the government favoring a particular religion. It's about a very specific sort of subset of that, religious animus. So the government is really just saying we don't like people of this particular religion. And so I think that to the extent you're going to say the Establishment Clause applies at all, that part of it has to. I think we may have to disagree on whether or not it applies. The last point that I would make, I kind of wrote this up and I don't know how much to go into it, but it's just sort of at least my reaction to the Trump administration and trying to remove this out of the political debate about whether or not you think that President Trump's policies are good. And I think that what we really have the last couple of years, I guess I should say, is that the game doesn't work if you don't have players that are willing to act in good faith. And at least, again, my political bias, I don't think President Trump is acting in good faith. I don't think that's all that controversial of a statement. And so Richard Clemens, who is a professor at Michigan, where I went to school, wrote an article on this, and he gave a couple of examples that I think are really helpful. So one is that the U.S. Supreme Court needs a quorum of 6 justices in order to act on a case. The 4 justices in the minority could just say, we're not going to play. We're done. We're just not going to participate. We're not going to sit. You guys can't do anything. And that's the kind of, I would argue, bad faith conduct that you don't see the Supreme Court doing. And there are good and important reasons why the court doesn't do it, why those 4 justices don't do it, even if they think the court as a whole is going drastically in the wrong direction. The other example I'd give is from Colorado, which is a relatively recent one, where, if you've heard about this in the state Senate, there was a debate about basically the Republicans wanted to slow down the process for the obstructionists, depending on what the persuasion is, and they asked that like a 2,300-page bill be read out loud, which stops the Senate for like 6 or 7 days. There was a whole court case about this, and the judge actually recognized that one of the relatively limited set of powers that a minority party has is to do this kind of thing, to require that you don't, to retract unanimous consent, to require that a bill be read in full. So there was a debate about that, but again, I mean, that's something that like the Republicans sort of did on one off. You can imagine a scenario where one party, the minority, just decided, I'm going to require that every single bill be read every single time. I haven't done the math, I don't know what happens, but you can imagine a world in which that means the General Assembly just doesn't function anymore. And so I think what we have with the Trump administration is the really difficult question of trying to grapple with, again, in my view, an executive branch that just isn't interested in playing by the rules in the same way that other people are, and that isn't arguing in good faith, or at least by the same set of standards that everybody else is. And I think that informs how the Supreme Court should look at the Trump travel ban. I think it informs the way that the court should review the emergency.
Thank you. Very good. I debated Richard Primus on this exact topic last year.
Oh, really?
So it's good. Was he your professor at Michigan? Yeah, I like Richard. We had a good debate. All right, let's take questions from the students. Hands, anyone? Come on, those are nothing we said that occasion thought. Yes, ma'am, in the front.
So I feel like we heard about the emergency declaration and travel ban a lot in like the beginning of February and haven't heard about it at all since then. The media has just been like completely silent. I actually just looked it up on my phone because I was like, I feel like I haven't heard anything.
You're right.
So what do you, like, has there been a stall on it in the courts? Like, I know there was a lawsuit filed by Crew, but what is kind of the future going forward?
Sure. So the biggest fake out, right? Trump's good at faking people out, right? He's very good at this. Is he announced this emergency executive order, but didn't actually say do anything, right? The initial executive order merely said that I authorize my government to use these sources of money to build a wall. Period. It's not build the wall, it's you can build the wall. So now it falls to the Homeland Security Department and the Department of Defense to actually decide where to construct. Now, Chris, correct me, I saw one order by DOD to build a 50-mile fence somewhere in Yuma, I think in Arizona somewhere. That's the only one I've seen, and there's already a lawsuit to try and stop it. So the reason why I haven't seen much is that they haven't built anything. It might take years. In fact, what I suspect is their strategy is to have the court declare the emergency legal first and then build. In other words, wait till the courts approve it. Because it's a lot easier if the courts say, well, this is just a declaration, nothing actually is happening, uphold it, then build it, right? The House Representatives filed a lawsuit, or they will file it imminently, challenging it. I think they have standing problems, but people who own property, right, this is easy. If you own property along the border, along the southern border, and they want to build a wall through your backyard, you have standing to challenge it. And I think those will be the suits that go forward. These cruise suits, whatever, I don't know. But the environmental groups, I think, have probably the strongest standing. I mean, California has basically said that we have standing to challenge construction in Texas, which I think goes a little bit too far. Maybe they can assert construction happening in California. If there are no plans to build in California, then I think their suits are premature.
Colorado actually joined that lawsuit.
Does Colorado have anything along the southern border? No, so
do they have other?
I think like Maine and like Washington State joined the lawsuit. I'm really struggling with those. Like I get California, I get New Mexico, Arizona, okay, Texas, but Maine, I don't get. Yeah, yes, sir.
I just wanted to probe your idea of the Youngstown test, but they're trying to find where that line of reasoning extends to. So is it correct to say you don't think it applies because this recent Congress, they voiced dissent, but it wasn't an actual legislative act, and you're basing it on previous, their last Congress's approval. So if we take that forward, at what point is it okay for Congress to show a dissent to an action?
So the question, right? How could Congress actually show their dissent? By modifying or repealing the National Emergencies Act. That would do it, right? There's in place a mechanism that Congress created because of Chadha to stop an emergency, and they failed to do it. So I can't read too much into it. They failed. But if they were actually to modify or to amend the Emergency Act, that would suggest that Congress opposed it. But again, I think it's a hard question. Could they retroactively modify it, right? If they gave the president this power and say we're now taking it away, they can take away future funding. So I think they'd have to basically modify the act. Youngstown, I think, is best where again, I love Justice Jackson, who's my favorite justice. He's a wonderful writer, but applying Youngstown to concrete problems leads to a lot of difficulties. And I think he'd be the first person to admit this. It's more of a general gist of how do we review these actions. Yeah, Rachel.
Is there a case law construing the definition of emergency?
Chris, I think the answer is no. Am I right on this one? I
Which isn't to say it's not reviewable. It just doesn't happen.
because generally, these sorts of things are not litigated. They're generally fairly, well, I shouldn't say generally. Some of them are long. We've had some in effect since the 1970s, from the Iran hostage crisis. We have some in effect forever, but there's really no, there's no litigation. The same way the travel ban statute doesn't define what detrimental means. This statute doesn't define what emergency means, and which is why I think you have delegation problems, right? There has to be something about what detrimental means. There has to be something about what emergency means. And if Congress does, I think the entire statute's void on its face. But to the extent that you don't agree with me, you like the New Deal, then this is a perfectly fine statute. So put that one at the end. Show my true colors. Yeah. Every Federalist talk has at least one dig in the New Deal. It's actually part of our charter. We're required to take one pot shot at Roosevelt every week. Mostly joking. Other questions? Going once, going twice. Anything else, Chris, you want to add? All right. Thank you all so much. Thank you.